Hello, welcome. Thank you for joining us for today's webinar, Maximizing the Online Economy and Making the Most of Your Copyrights, Part 3, focusing on the film industry, filmmakers, videographers, and the like. I'm Meredith Badler. I'm the program director at the CBCA, and we are delighted to bring you today's webinar and presentation. The program will be led by the terrific entertainment and business attorney Max Hass with Hass Law, and we'll turn it over to him in just a moment, but I wanted to share a few thank yous and housekeeping items before we dive into today's great content. Really the impetus for today's webinar was understanding that folks in the creative sector with the impact of the coronavirus and all of these various shutdowns are needing to find new ways to leverage their creative content and to protect their creative content as they're putting it out there in the world. So today's presentation will really focus on a basic understanding of copyright law and understanding how to protect your work and who owns it and how to work with collaborators and make sure you have a good understanding of your ownership rights. And then with that understanding, then putting it out into the marketplace and leveraging it, particularly in our online economy that we find ourselves in. This program is being presented by CBCA in conjunction with some of our longstanding programs. One of those is Colorado Attorneys for the Arts, or CAFTA, as we call it. CAFTA is a pro bono legal referral service, as well as legal education for artists that we've been running for several years now. And we get support for that program from Colorado Creative Industries, Create Denver with the City of Denver, and the Colorado Bar Foundation. So thank you to them. In addition to CAFTA, CBCA recently launched a program called Advancing Creatives, which is a whole suite of other professional development and business skills trainings for artists and creatives. And we are thankful for the generous support from the Kenneth King Foundation to really launch that program. Today's webinar and all of our webinars that we've done in the last few weeks and going forward will live as recordings on the Advancing Creatives page, so that will continue to become a resource for artists now and into the future. So we are recording today. And with that, a few comments about Zoom. This is a Zoom webinar. To all of our attendees logged in right now, you are muted and your camera's turned off. You're here to listen and participate through the chat feature or the Q&A feature. So throughout today's presentation, we hope you have thoughts that you want to share, questions you might need some additional clarification on. Max is here giving this presentation, and we'll be keeping an eye on that chat and the Q&A feature, so we'll be able to answer those questions and respond to your thoughts in real time, which is very helpful. I'm also joined by one of our staff members, Rachel, who will be helping out moderating and hosting this webinar, so we can also help respond to some of those chat questions as well. So please stay engaged, let us know what you're thinking, ask questions. We're here for you and to help you out. I think those are all of my housekeeping items for the moment. It's my pleasure to introduce Max, our speaker today. As I mentioned, he's a business and entertainment attorney, as well as a musician and a creative himself, and we're delighted to have him. So with that, we're going to do the screen share switch. I will close my screen share. We'll turn it over to him to lead today's presentation. Thanks.
Thank you, Meredith, and thank you everyone else for for being here today. I know this is a challenging time, so the fact that you're taking the time out to listen to this means that you really care about trying to figure out some business things, and so we appreciate you taking this time with us. So before we get started with the formal content, I do always need to just kind of provide this basic disclaimer just so that you're all aware ahead of time that this is an educational class, so I won't be providing legal advice today. There are some best practices and some things that I generally recommend to all of my clients, kind of regardless of the specifics of their case, and I will share some of those with you today, but I won't be giving any specific advice as to a particular legal matter or legal concern that you might have, because the purpose of the overall workshop is really to impart some education upon you, and since you have the basic information you can use to have informed and productive conversations with your collaborators, your business partners, your attorneys, managers, anybody else who might be involved in kind of the management of your creative business. So that being said, if anybody does have questions about their specific legal matter, or they do have a particular concern, because of confidentiality reasons, I just ask that you refrain from putting those questions to the whole group. But with Zoom, you do have the ability to send direct messages to individual people. So you can message me directly, or you can send me an email, and I'll post my email address in the chat box so that you have that available. So getting right into it, I just want to tell you a little bit about me. As Meredith mentioned, I'm an entertainment attorney and musician. I do also work with clients on business formation matters and things like that. So really try to provide kind of the full suite of services that creative people may need in running their businesses. I went to Tulane University in New Orleans for law school, and stayed in New Orleans for about 4 years, working in the music and film industries during that time, until I relocated out here to Denver in October. I've been doing workshops like this one in person for over 5 years now, but this is actually, aside from yesterday and the day before, this is really the first time we've taken it to the digital realm. So I appreciate CBCA's efforts in creating this platform. And as I've sort of mentioned, my primary clients are creators, right? So I work with musicians, filmmakers, photographers, illustrators as sort of my core client base on pretty much day-to-day basis. And so to give you a little roadmap of where we're going, as Meredith mentioned, the focus of this presentation is pretty heavily centered around copyright issues. And so for some people, they may have an understanding of some copyright issues already, but I always include a pretty detailed coverage of copyright law, because copyright is what forms the value in your creative work. So the ability that you have to demand payments, royalties, things like that, all directly derive from the exclusive rights you have in a copyright. And so all of the commercialization and monetization things that you need to be thinking about as you sort of approach this like a business, all ultimately require a knowledge of copyright, so that you know what you can do with the work and what you can't. So we're going to start with copyright. We're going to talk a little bit about contracts that affect copyright and what sorts of things to look out for in that scenario. We'll definitely talk about issues involving joint authorship, since that's a very, very common issue in the film world. But then I'll also kind of walk you through briefly a little bit about copyright registration, since that's a very important step before going out into the marketplace with your work. And then we'll discuss some avenues for kind of making the most of this sort of new economy. Hopefully it's a temporary economy, but since we don't know the end time of this period, it's new for now, and we need to see how we can continue functioning in it. So start off just to kind of cover one very, very common misconception I've seen over the years, is that people tend to sort of use copyright and trademark and patent kind of interchangeably. But the reality is that all three of these areas they do fall within the umbrella of intellectual property, but they're not interchangeable. So copyright trademark, and patent are all three separate forms of intellectual property, but they are not equivalent to one another. They're governed by entirely separate federal statutes. There's totally different case law connected to copyright and trademark and patent. And probably most significantly, and maybe the easiest way for you to remember the differences for our purposes today, and for you to just kind of have a general understanding, is that copyright applies to creative expressions, whereas trademark applies to logos and brands. And specifically, trademark doesn't actually protect the creative, expressive elements of logos, but actually only protects the company's right to use those logos or brands as kind of an identifier of their company. So it's kind of a different legal right that trademark protects, whereas copyright specifically protects the creative expressions. And then patent is used for inventions, right? So if something is sort of a functional device, it's probably more likely going to fall under patent law than under copyright law. Though, you know, there are some overlap of these three areas. It's important to recognize that you can't just use these terms interchangeably. So when we talk about getting a copyright on something and we talk about getting a trademark on something, we're talking about two very different forms of legal protection. And there are limits to what each of those areas can be used. So just kind of start with the very basics, just to sort of orient you in terms of how copyright functions economically. The most important point that I always emphasize to folks when I'm first kind of introducing them to copyright is you really have to recognize that it's a form of property, which means that you can buy it, you can sell it, you can rent it out to people, which in the copyright world we call licensing. And as a form of property, it's actually separate from the artwork itself. So the easiest example to think of there is kind of comes from the visual art world, where you have maybe an original painting on a canvas and some wealthy art collector wants to buy the original to hang it in their house. If they buy the painting itself, they are not necessarily buying the copyright. And vice versa is also true. Someone could come along and say, hey, I really, really love your artwork. I want to go and start a line of poster prints that use your artwork. I want to buy the copyright from you. The artist is free to hold on to the original canvas painting and can still separately sell the copyright. And so that's a really important concept, because that really sets the stage for what you can do on a basic level. And that's why you're able to do things like licenses and assignments and other things like that. Copyright is governed entirely by federal law, which is different from most types of property, which are usually the province of state law. So the important takeaway there is that copyright and the rules that we're going to be discussing in this presentation apply pretty much the same way everywhere in the United States. So while there are some nuanced differences based on case law that we won't get into today, the vast majority of the copyright rules in the United States apply the same way regardless of where you are. As a form of property, think of copyright like a bundle of rights. And on the very next slide, I'm going to tell you what those rights are that are bundled together. But it's a bundle of rights for which the owner has exclusive control, which means that they can stop other people or exclude other people from using those rights during the time that they own that copyright. And unlike other forms of property, those rights actually expire after a certain amount of time. So copyright law dictates our current present day copyright law says that the copyright lasts for the artist's entire lifetime plus 70 years after they pass away. So it gives you a lot of time for your heirs, even the next generation of heirs after them, usually, to still be able to enjoy the benefits of that copyright. So if you have a work that's perhaps already making money, that even after you've passed away, your family can continue earning money from your works. There are slightly different rules when a company is considered the author of the work, which only comes into play when the work for hire doctrine is effective. And that is a very common issue in the film world because work for hire does apply to films, unlike other forms of art where work for hire doesn't really apply to music and visual art. It does explicitly apply to the film world. And so when a company is considered the author because of the operation of the work for hire doctrine, the duration is actually either 95 years from when the work was first published or 120 years from when the work was first created, whichever time period is shorter. So I know that can be a little bit confusing when you think about it in the abstract, but if you think about, go back in time, think about a work that maybe was created in 1930, but then wasn't actually released until 10 years later, that's where you kind of look and see, all right, 120 years after it was created in 1930 would bring you to, 2050, but it was published in 1940, so 95 years after that actually brings you to 2035. So the copyright would expire in 2035, not in 2050 in that scenario. So that only comes up where the company is considered the author, and we can discuss work for hire in a little bit more detail later on, especially if there are specific questions about it. But it's important to know as a general concept that all copyrights expire at some point. And when they do, they fall into the public domain and nobody else can claim a copyright over something that's already in the public domain. So not really an issue for most people to be too concerned about present day because it's actually legally impossible for a copyright to fall into the public domain during your lifetime. But you still should know that those rights do expire at some point. Now, what that also means is that older works that were created a long time ago may be in the public domain. And there are some situations where the question of whether something's in the public domain is a little bit tricky to figure out and requires some research and a little bit of digging. But we can say for certain that everything created or published in 1924 and earlier is 100% in the public domain. And starting next year, it'll be everything from 1925 and earlier. And so every year we're going to keep seeing a new wave of things fall into the public domain. So if you're the kind of filmmaker who likes to use archival footage and archival photos and other things like that, that's something to think about, because if something's in the public domain, you don't need to clear it. You can just go ahead and use it as is. So duration rules can come into play when you're looking at that sort of thing. But I think that's about all I need to say about that. So I mentioned that a copyright is a bundle of exclusive rights. So those rights are these ones listed right here. Okay, so in the US Copyright Act, which is a federal statute, there's a section of the law that specifically lists these 6 rights as being the exclusive rights that belong to every copyright owner. So regardless of what kind of work it is, regardless of how it was created, if you are legally the copyright owner or one of the copyright owners, you will have all of these rights. Now, I'll just point out that the number 6 down at the bottom only applies to sound recordings. So filmmakers, for the most part, don't need to concern themselves too much with that. That's mostly the province of the music industry. But like I said, these rights in general do apply to every kind of copyrighted work. So you have the right to copy it, to distribute it, of course, to publicly display it, publicly perform. But you also, as the owner of a copyright, have the right to authorize derivative works as well. So, a very common scenario for that in the film world is where someone wants to create perhaps a narrative film based on a novel or a series or comic books or things like that. Those are all pre-existing copyrighted works. And so the owners of those literary materials, books, comic books, whatever is used as the basis of your film, they have to expressly give permission before a film can be made based on that. And that's because they have this exclusive right to make derivative works right here. See, there's a question that popped up. I will probably not be addressing fair use in any significant detail because it's kind of a complicated concept. But if you do have specific questions about fair use, we can definitely discuss that one-on-one. Or if you do have kind of a general question that you think, maybe that would benefit the audience, I'm happy to discuss that at the end of the presentation when we have a few minutes to talk. So I'll just leave that off to the side for now. So like I said, these rights apply to every copyrighted work, recognize a specific list of types of works that are eligible for copyright. And the reason these are listed out this way is because the Copyright Office uses these labels as part of the registration process. So your work has to fit into one of these categories as a basic matter in order for it to be eligible for copyright protection. And that being said, each of these categories is quite broad. There are a lot of different types of things that count as literary works. Musical works are a little bit more limited to specifically songs, more or less, but literary works are very, very broad. It includes pretty much anything that is written in some form. Now, the two that are probably most important for the film world are dramatic works and audiovisual works. And in particular, when you think about a narrative film, you actually have quite a few different copyrights involved. So your screenplay, actually taking it a step back, your treatment for a film might be considered a literary work because it's just a basic document with text, right? You're just describing an idea, you're sketching out characters, other things like that. But your screenplay is actually going to be considered a dramatic work. And then once you actually go into production and start creating a film and you're recording images with your camera and you're recording audio, now the finished film is actually going to be considered an audiovisual work. So the significance of this is, remember I mentioned that copyrights are property, right? So your screenplay, the copyright in that screenplay is one distinct copyright. And then the audiovisual work, the film that you've created based on that screenplay, is a completely separate and distinct copyright as well. So what that means is that throughout the filmmaking process, there are a number of different pieces of property to sort of identify and take the time to look and see, all right, who's the author and the owner of this particular copyrighted work? Who's the author and the owner of this other particular copyrighted work? And the significance of that is that in order to make use of different copyrights, it's very important to have contractual agreements that kind of link these properties together to make sure that you have a clear chain of title. So that's what we'll be discussing over these next couple of slides. But before we do that, one thing I have to emphasize, even if your work falls into one of the categories on this list, it still has to meet the basic threshold requirements to be eligible for copyright in general. So you could have a literary work or a piece of writing that you believe fits into the category of literary works. But then the question still remains, has it met these two threshold requirements? Is it an original work of authorship, and is it fixed in the tangible medium of expression? These are the two requirements that are actually in the copyright statute. They're used over and over again in copyright cases where issues of ownership are at issue or being litigated. And so, these aren't necessarily very difficult requirements to meet, but it's still important that you know where the line is. So an original work of authorship doesn't really mean that it has to be something really novel or groundbreaking. It just has to have some minimum degree of creativity. So if you're simply just duplicating facts or creating a list in names or a list of addresses or something like that, courts are probably not going to see enough creativity in something like that. But if you've added some kind of creative, expressive element to it, that's pretty much all that needs to happen in order to meet that first hurdle. The second hurdle, fixed and tangible medium of expression, seems like kind of a jargon sort of term, but it's also sort of self-explanatory in that the work has to be tangible in some way. It can't still just be an idea in your head. So take the time to, capture some rough footage on camera, or to take some photos of, some locations, or to write out your character bios, or other things that once they're sort of permanently affixed to some sort of medium, whether it be a hard copy piece of paper or a digital document on your computer, it has to at least exist in some way that another person could come along if they wanted to and perceive your work and would be able to copy it from seeing it. If it's still in your head, nobody's going to be able to do that. And so there's not enough of that fixation element in order to be eligible for copyright in that scenario. So, things like, where the water is coming up, by itself, that drawing can't get copyright protection because it's not fixed. It's going to get washed away in a matter of seconds. But if you take a photo of it, now you've fixed it in that tangible medium, which is the photograph, and you could actually get a copyright over that drawing because you have fixed it in that photograph. And there might even be a separate copyright for the photo itself, but that's kind of a different story. And so related to this, the copyright comes into existence at the very moment that, that the work is fixed in a tangible form. So clients ask me this all the time, am I unprotected if I don't go and register my copyright? Well, no, actually, those 6 rights I just showed you a few slides back, you have those rights the very same moment the work comes into existence. So as soon as you have written something down on a piece of paper or captured a photograph, the work that you're trying to claim protection over gets that copyright as soon as that fixation has occurred. Assuming, of course, you've also met that original work of authorship hurdle as well. But the basic idea here is that you get that legal protection as soon as you've created the work of art, and you have that protection even up until the time that you go and register the copyright. So you never, unless the idea is still in your head and you haven't actually gotten it down some way, there's never any period of time where your work is not copyrighted. It's actually always copyrighted from the moment it exists. Now, just to kind of give you a sense of what the limits of copyright are, there are certain things that can't be copyrighted because they're either not original enough, or they're not fixed, or for policy reasons. So we have certain things that are covered by other areas of intellectual property law, right? We have things like designs and useful articles, inventions, machines. Those are all covered by patent law. And so because they are the province of patent law, copyright explicitly doesn't cover those things. And similar with trademark law, there's certain things that are covered explicitly by trademark law, and so copyright kind of stays away from trying to, create sort of double coverage there. On that point, just an important thing to point out is there is no copyright for titles. So a film, a painting, a song, you can copyright the work itself, but you can't copyright the title. Now, in the film world, TV especially, you can get a trademark over the title of a series, but you can't get a trademark over the title of an individual film. So things like, the Harry Potter series or the Star Wars series, those are seen as a franchise. And so each film is kind of an installment of this bigger franchise. And so there's a trademark for the Star Wars name or for the Harry Potter name because they're being used in connection with that series. But copyright is explicitly not available for that. So something to be aware of. There's also other policy considerations. Copyright law has its limits, and we don't want people to be able to tie up, basic familiar symbols and other building blocks, right? So, in the film world, what that means is we have these sort of general character types, right? Or we have these sort of classic story arcs, like a rom-com or like a horror, where you have kind of similar sorts of things might happen throughout the plot. Nobody can get a copyright over that general concept, because if you did, you'd be able to stop everybody else in the world from being able to make a rom-com. So what you can get a copyright over is the specific creative expressive elements. So if you have a particularly unique character, or the specific sequence of events that take place in a film, or the specific way it was shot, or the audio you used, a lot of that stuff can be copyrighted, but the basic concept of the story arc generally can't. Similar idea there for characters, but those get a little bit more complicated. And so if anyone does have specific questions about that, we can definitely address those. Okay, so that gives you a sense of what can and can't be copyrighted, and kind of how the copyright comes into existence and what rights you have. But it's also important, probably equally important, to figure out who it is who actually owns those rights, right? So, as an initial matter, we have to determine who's considered the author of the copyrighted work, but we also have to figure out who the owner is. And even though these are, ordinary words in the English language, within the context of copyright law, they do have a specific meaning. So an author is a sort of legally relevant term in copyright that means somebody who has made a non-trivial creative contribution to the work. And an owner is defined as somebody who actually controls the copyright to that work. So the owner is the one who gets to decide whether or not to exercise those exclusive rights that are included. The owner gets to be the one to issue licenses, to enter into distribution deals, to hire people to work on a project. Though actually, I'm going to scratch that, because that's kind of a little bit of a different situation. And what's important here is that the author and the owner can and often are the same person, but it doesn't have to be that way. And that's why we have these two separate terms, because it's possible for an author to transfer their ownership in that copyright to somebody else, or even just a portion of their copyright to somebody else. So it's very easy for there to be, different people who occupy these different roles. I'm going to pause for a second. It looks like we have a question here. What does a writer say to a producer who insists that they be listed as an author or a co-author of the writer's work? Well, that's a good question. So remember I mentioned earlier that when it comes to films, there's actually usually multiple copyrights involved. So a writer would typically be the person who's creating the screenplay, right? And then a producer usually gets involved a little bit later on in creating the audiovisual work. And remember, these are two totally separate copyrights. So the writer, if the writer worked alone on the screenplay, is going to be considered the sole author of that screenplay. Now, if the producer then comes in and has a bunch of revisions and actually adds this non-trivial creative expressive material to the screenplay, then maybe there's an argument that the producer and the writer are now co-authors in that sort of new version of the screenplay. But you really have to look first at how did the authorship come about, right? So you look at the facts of how was that screenplay created. Then the next step, first of all, I have to point out here is that anyone who's considered an author is automatically going to be an owner of that copyright. So from the minute of fixation, from the moment that the scriptwriter finishes that screenplay, copyright exists in that screenplay, and the writer is the sole owner of the copyright to that screenplay. What often happens in the creation of films is that a producer will then buy the copyright from the writer. And the reason the producer wants to do that typically is because you need to have full ownership and control of the copyright in order to then make the film, but then also to get distribution down the road. So that's how that kind of chain of events works. And then the writer is also generally going to be considered a co-author of the finished audiovisual work, because the audiovisual work could not have been made without that screenplay kind of dictating what shots there should be, what dialogue is going to be read, and all of that. So to this question that was raised, if a producer is trying to retroactively go back and say, I want authorship credit of your screenplay, they have no legal basis to demand that. There's literally nothing in the copyright law that entitles them to do that. So, you know, obviously you want to be diplomatic in your relationships and not just, you know, alienate people or burn bridges. But the key takeaway there is basically the writer needs to tell the producer, you didn't help me write this script, so you can't be considered a co-author. If you want to own a piece of this script and get some of the money, you are free to make me an offer and buy the copyright from me, or a portion of the copyright from me. But there's no legal basis for someone to come into the picture after a work has been created and retroactively assign authorship credit to themselves. That's just legally not something you can do. Now, what I've experienced in working with creatives is that lots and lots of people don't understand how copyright works, but they think they do. And what happens when someone has sort of incomplete information is that they try to sort of demand things based on whatever they think they know, and they don't take the time to go and look and see what the law actually says. And so, you know, that's a common issue. And then the follow-up question here says, what if it's their idea, but no writing was involved on their part? Well, remember what I said before. If someone has an idea and it's not fixed, but it's still just in their head, or if they just verbally kind of tell it to other people, that's not enough to be eligible for a copyright. So the key thing here, so I'll use this as a good segue. So to try to just clarify this for everyone else who's listening, you have basically two different scenarios that can happen here. You have the situation where a copyrighted work is created by just one person. And in that case, there's one author who's automatically going to be considered an owner, and they're the only sole owner. They own 100% of the copyright to that work. The other possible scenario, of course, is where there are multiple people involved in the creation of a work. When you're in that second scenario, when there's multiple potential authors, the analysis that you have to do is, first, you look at what exactly did people do? And I kind of mentioned that earlier, is you just look at the facts of how did this get created? But the legal analysis asks basically two questions. One, did each of the authors make an independently copyrightable contribution to the work? So they have to have met this, I'm going to try to go back to this slide here. So each author has to meet both of these hurdles here. Each of them has to contribute something that is an original work of authorship and that is fixed in a tangible medium of expression. So a good example of a screenplay that is truly co-authored by two people is where two people are both writers, they both sit down together, they're discussing things, you know, one or both of them are actually writing out the dialogue and the blocking and the, you know, and the shots and all of that kind of stuff. And maybe they're revising each other's work and things like that. But if one person is doing the actual expressive work of writing out the dialogue and the other person is just sort of chiming in with ideas, well, even if that other person's ideas would be considered an original work of authorship because they're creative in some way, but it's not fixed in a tangible medium of expression, then they can't have made what we call an independently copyrightable contribution to the work. because every author's contribution has to be analyzed under these two hurdles. And then the next thing you look at when you're dealing with this joint author situation is, did the parties intend to merge their talents into one unified work? So first is each person's contribution independently copyrightable, and did both parties intend to merge their talents into one unified work? And if the answer to both of those questions is yes, then you are in that co-author situation, and the two authors will be considered co-owners in that work. But if one of the authors is really just sort of throwing ideas out there and isn't actually doing any of the work to create the script, to write it out, to write dialogue, to make revisions, to actually fix their contributions in some sort of tangible way, then their claim of authorship over that work is really dubious. And so, unless they can really factually establish that they contributed to the creative, expressive elements of the work, the default provisions of the law will say that it's the person who actually made those expressive, who got those expressions down in some sort of tangible way, that will be the person who's considered the author. Now, this can get kind of fuzzy. People have different interpretations of the facts, especially if you're looking at it after the fact and kind of going back to try to figure it out. But that's where it's important to just try to remember things as detailed as you can. And if you do get into a genuine dispute about it, it's often very helpful to work with attorneys on this, especially attorneys who know copyright law, and they can usually help you find a resolution there. This is also really highlights, and is actually a good segue to the next slide, that all of these authorship and ownership things can actually be modified by contract. So all of these things that I explained on this slide about the author automatically being an owner of the copyright, you can actually enter into contracts that change the ownership of the copyright. I'm going to get into that next. So there's sort of two different phases of any copyrighted work where contracts are important. There's sort of the early stages, which is either before you've started working on something, or maybe at some point during the process, you sit down with your collaborators or anybody else who's involved in the project in some way. You say, hey, I'd like to get some contracts together. I'd like to discuss how we're going to handle the copyright ownership of this work. I really want to make sure that, we don't have any confusion or miscommunication, or that anything is sort of left ambiguous here. And the copyright statute allows you to enter into contracts where, even if you have multiple collaborators, you're legally allowed to have those collaborators transfer their ownership to you. So if you're working on let's say, just going back to the screenplay example, if you're working on that with 3 other people, but 2 of those people are, they have full-time day jobs and they're not really going to be involved in trying to get the script sold, but there's one writer who's, really plugged into the film industry and is really trying to get the script turned into a film, maybe that writer wants to kind of be in charge of the project. So what that writer could do is actually get contracts in place with the other 2 collaborators, where the default rules of the copyright law would say that you're all equal three owners with a 33% share each. You can use the contract to either sort of tweak those numbers, and let's say maybe the writer who's in charge of the project wants to have a bigger share, but they still want to, allow the other 2 people to own a piece of it. You can make it a, 20-20-60 split if you want, or really whatever other numbers you want. So you can do that. You can change the proportions of ownership, but you can also have ownership transferred outright. So you could have these 2 other co-authors, and you can have them actually sell you their entire stake the 33% that each of them owns, you can actually have them transfer that to the one author who's going to be in charge of the project. And then once those contracts are signed, the person who has received this copyright ownership from the other two contributors now owns 100% of the copyright. So in that scenario, when you use that contract to do that sort of thing, you still have three authors, because when someone's an author of a work, except for work for hire, for the most part, if someone's an author, you can't take authorship away from somebody. But that one writer at the end of that process, after signing those contracts, will become the only owner of the copyright. So that's kind of a good illustration of seeing how you can have that separation between author and owner. You know, you could have three people writing something together and all three of them sell their copyright to a totally unrelated, third party, So what I like to describe these types of contracts as contracts you use to establish clear chain of title. And this is a term that you'll see if you start talking to distributors and other entities that typically license films or buy films. They want to make sure that when they're buying a film or a script or something that has copyright protection from a creative person, that there aren't other people who are going to come up later and say, oh, I actually was a co-owner of this screenplay and I didn't sign off on, this work being sold to you. And then they sue for infringement or they demand a bunch of royalties. So companies like distributors really want to avoid that situation. And so they typically want to see that the person who's coming to them with a project has clear chain of title on that project. And so in order to do that, that means getting contracts in place with everybody who is involved who might be able to make some kind of claim of copyright authorship and ownership. And so in a film, that's a lot of people, right? And so that's why, we use deal memos in the film world. Is every single one of your crew members, even if the default copyright law wouldn't necessarily give them authorship credit, this is just kind of a best practice to make sure that you have no issues that are going to pop up later on. You have every member of your crew sign a deal memo. That deal memo is going to include a clause that assigns their interest in the copyright to the film over to, let's say, the producer of that film. Another contract that's very common and established in clear chain of title, let's say that you're playing the role of producer here, is obtaining that script. Most of the time, producers will actually buy the script outright. They're not licensing it from the author of the script. They're actually buying the copyright to it. And then that way, the ownership of the script and the ownership of the audiovisual work are all vested in the same person. And then that one person can go to a distributor and be able to sign off on getting the film licensed, distributed, and so on. You might also have scenarios where you're commissioned to create something. Someone approaches you and says, I want you to create a TV commercial for us, or I want you to do a short film about our facility, or I want you to commissioning this documentary about somebody. In that scenario, the work for hire doctrine might apply, and there's often a lot of confusion about who owns the copyright when someone is commissioning another work. And so a contract there will help make sure that you establish very clearly whether the filmmaker retains copyright ownership or whether the commissioning party is going to be owning that copyright as a result of having hired the filmmaker. And I do have a slide on work for hire at the end of the presentation. So if folks want to dig into that a little bit deeper, which I know is of some concern in the film industry, is understanding how work for hire works. We'll try to get to that at the end. And then the other, phase to think about contracts, and the reason I separate this into two phases is because you're going to see different types of contracts, different categories of contracts entirely, really. And so this second phase is really after the work is done and you're ready to take it out into the world and start commercializing it. The types of contracts you see there are going to be license agreements, or it might be a distribution deal that contains a clause within it that has some sort of license or assignment. So sometimes these can be standalone documents, and sometimes a license or an assignment will be contained within a larger contract. Just to make sure everyone is clear, assignment is just the term we use in the copyright world to talk about a sale. So when you license something to somebody, you're still owning the copyright and you're just giving someone else some form of limited permission to use the work in some way as defined in your license agreement. But an assignment is a sale. So when you assign your copyright to somebody, you give up your ownership of the copyright, and this other person you assign the copyright to becomes the new owner. And so that is, like I said earlier, a very, very common way that producers for at least narrative films will obtain the script to use for their film. And in fact, the first contract that's used is typically an option, and then the assignment comes later once the film has actually been greenlit for production. But the assignment is a really important legal concept, because when you assign your copyright, you cannot get it back unless you buy it back, just like any other form of property. Once you've sold it, you can't just say, oh, never mind, I changed my mind. You're going to have to buy it back from the person that you sold it to. So I just want to pause right here for a second. Would folks like to see me talk about work for hire right now, or do you want to get through kind of the copyright registration stuff before we circle back to that? And please just chime in the chat feature, and I'll see what people say. See one vote for work for hire. Okay. Well, I have to scroll down to the end here, so you'll get a little preview of the other slide. But so let's talk about work for hire doctrine. So work for hire is a concept that applies generally sort of throughout, there we go, applies generally throughout the copyright world, but it's particularly important in film because work for hire doesn't really play out the same way in music and visual art and other fields as it does in film. So where work for hire comes up is where one person is hiring another person to create a copyrighted work or a copyrightable work. So it could be, you know, something creative. It could be a commission situation, or it could be, you know, you as the filmmaker hiring crew. Whatever the dynamic is, it's still the same basic concept, right? You've got one party hiring another to create some kind of creative work. Now, there's two ways this typically plays out. The person being hired is usually either an employee who has, you know, W-2 tax status and receives a regular paycheck and gets taxes withheld, you know, reports to work at a specific workplace every day, what you sort of typically think of as being an employee. That's one option. The other option is where the artist is not an employee, or whoever the person being hired is not an employee, but is instead more of a freelancer. And there's slightly different requirements for how to get work for hire to work effectively. That fundamentally depends first on that person's employment status. So I'm going to sort of do this slide backwards here. First, just to kind of orient you, what work for hire means legally is that if work for hire is effective and applies to your situation, the hiring party becomes the author of the work, not just the owner, but also the author. And the effect of that is it means that the person who actually did the creative work, the person who's the actual artist who had the original work of authorship and fixed it in a tangible medium, that person will actually not even be considered the author. And instead, it's the person who hires them who gets authorship status, which means technically that when the hiring party, the company or production or whoever it might be, can go to the Copyright Office and register the copyright and list themselves as the author, and there's no legal requirement that they actually list the other person's name anywhere on the copyright registration. So a really common example of this is, think about like a big film studio that employs, I use Disney for this example. They employ a bunch of illustrators. Those illustrators are, typically salaried employees of Disney, right? They show up to work every day. They work on projects at someone else's direction. Materials, workspace, other things like that are provided by the employer. And the result of that is that Disney, not the individual animators or illustrators, but Disney itself is going to be considered the author of the film that gets produced as a result of their labor. Now, that's the effect of work for hire. So now you kind of see why it's so significant. But very, very specific steps have to be taken in order for work for hire to apply. So as you can see here, there's two ways that it can happen. One, employee. If you're an employee, work for hire is going to apply. That's pretty much the extent of it. So if you're an employee and the work that you've created is within the scope of your employment, then work for hire will apply and your employer will be considered the author of the copyrighted work. Now, if you're an employee, but you create something on your free time at home with your own materials and when you're not on the clock, then that's not within the scope of your employment anymore. And so work for hire can't really apply to that. So it is important to really look and see, okay, did we create this within the scope of my employment for this company, or was this something that I was doing independently? Sometimes there are scenarios where that can get a little bit fuzzy, like if you're, bringing tools home from work or using your workspace after hours when no one else is there. That can create some, more tricky situations to kind of untangle. But generally speaking, work for hire with W-2 employees is pretty straightforward. Now, if it's not a W-2 employee and it's a freelancer, it's a very different set of steps that needs to be followed. First off, you need to establish that this person is an independent contractor. And sometimes there are disputes and disagreements over that. I had a client last year or about a year and a half ago who considered herself to be an independent contractor, but went to work for a company that hired her to paint some murals. And the company basically had her working at their business in their space when the business was open. And so it was a little bit fuzzy whether or not, she was truly an independent contractor because she could only work within the hours that were dictated by the hiring party there. And so it was a little bit of kind of a blurred line there between employee and independent contractor, which affects the analysis here. But to teach you this, just take the clean and simple example where for a fact the artist is an independent contractor, they're a freelancer, and they're hired for a particular project, right? They're not a salaried employee who's going into work every day, but they're hired one-off for that particular project. In order for work for hire to apply in that scenario, there's two requirements. So when you're in this umbrella of independent contractor world, two requirements are that the work falls into one of 9 statutory categories. And I'll list those in a second. And then there also must be a written contract signed by both parties that includes the words work made for hire. You have to have all 3 of those things. It has to be written, signed by both parties, and says the words work made for hire. So you could have a contract that doesn't include the words work made for hire, and work for hire would not apply. So it's really important that all of these pieces have to be there in order for work for hire to apply. And the reason I emphasize this is because I have worked with artists over and over and over again who do not use contracts when they work on commissioned projects. And what happens is the party that hires them thinks that work for hire applies because they've paid for the work, but they never had a contract that explicitly established that work for hire applied. And the result is that the artist remains the author and the owner of the copyright. So all of these pieces have to be there. Now, these 9 statutory categories, most of them are not things that artists really encounter on a regular basis. There's contributions to a collective work, which means like entries in, say, an encyclopedia, for example. You have a lot of different authors who are each writing different little pieces of it. And then the result is sort of this compilation of a bunch of materials, translations, supplementary works, which I don't actually even know technically what that means, compilation, instructional text, tests, answer material for tests, atlases, and the most important one is as part of a motion picture or audiovisual work. So of those 8 works I listed earlier, literary, dramatic, music, etc., motion pictures and audiovisual works are the only category that's included in the work for hire doctrine. So what that means is that freelancers who work on film projects do fall under the work for hire doctrine. And as long as there's a written contract that says work for hire and it's signed by both parties, work for hire will apply. So what that means is, unless you're working in California with that awful AB5 law, as a film production, you don't need to hire people on as W-2 employees in order for work for hire to apply. You can still make that happen with independent contractors as long as you use the proper language and the proper format for your contract. So I think most filmmakers who have some experience in this area already are familiar with the practice of using deal memos. So really the only thing you need to do there is make sure that your deal memo has the language that says work for hire, and make sure that the contract ends up getting signed by both parties, and you'll pretty much be good to go. And what that will result in is that the producer or whoever's in charge of the project will be the only author and thus owner of the copyright. So what's important to know here, just to really drive this point home, is under the independent contractor scenario, if you don't have a contract, work for hire won't apply. If the contract is not signed, there's a pretty good argument that work for hire will not apply. If you have a written contract and it's signed, but it doesn't have the words work for hire is probably not going to apply. Even if you have all 3 of those things, but the work doesn't fall within these 9 statutory categories, work for hire also doesn't apply. So for film, it's pretty much always going to apply, but it's important to emphasize this because, like I said, there are examples where painters, muralists, photographers are commissioned by other people to create things, and the hiring party thinks that work for hire applies, but if it's not on this list of 9 categories, then work for hire doesn't apply. Now, you can still transfer ownership via an assignment, right? I mentioned that earlier. So even if work for hire doesn't apply, a producer or whoever the hiring party is can still get copyright ownership by having a clause in a contract that says that, person 1 assigns their copyright interest to the producer, but the producer will still have to list that person as an author of the work, even if the author doesn't have any ownership. So I hope that pretty much addressed concerns there. But of course, if you have any questions about work for hire, please let me know and we can address that. I'm going to scroll it back here now, and we're going to talk a little bit about copyright registration. Okay, so here we are. This is a screenshot of the Copyright Office's homepage, copyright.gov. Make sure you're at copyright.gov because copyright.com will not look like this. This is managed by the Library of Congress. This is an official federal government website. And so the first thing you're going to do when you want to register is you have to click here on register, which will take you to this next screen here. It's kind of a splash page, and then you want to click on login to the ECO registration system, which will then take you to this page here. If you don't have an account, you will need to create one. It's free to create one, but it's obviously just a basic sort of login here, so it's not anything that involved. They just want a user ID, your email address, and a password. But then once you're in there, you'll be able to start a new registration, manage your existing registrations, look at the status of registrations as they're sort of working their way through the Copyright Office system. And you can also save drafts. So you could go in and start a copyright registration, but maybe if you're missing some of the information you need, you can save it, log out, come back to it whenever you need. And then once you are ready to register, those drafts will be sitting there waiting for you, and all you have to do is finish those last couple steps. So why register a copyright? I think, plenty of people do understand that on a general level, the copyright registration is important. And as I mentioned earlier, you do have a copyright even if you don't go to the Copyright Office and register it. But there's still a lot of really, really important reasons to register a copyright. First and foremost, if you register the work within the first 5 years after the work has been published. So once you've released your film or otherwise kind of made it available for public consumption, if you register your copyright within the first 5 years after doing that, you're going to get what's called a legal presumption of ownership and validity. Prima facie proof that you own the copyright and that the copyright is valid, which is really important in general, so that the whole world knows that you actually have a copyright in your work. But then also, if you end up in a situation where you're in litigation, you have an infringement dispute, having a registered copyright where the work was registered within those first 5 years is going to cut off a lot of arguments that the other side might have if they say, oh, but we actually own the copyright, or we actually came up with this idea. Because if you can prove that you went and registered it before they started infringing, you'll have a significant leg up in that litigation in order to show that you're the proper owner and that someone else infringed your rights. Related to that, you actually need to have the copyright registration certificate. So not just have submitted the work for registration, but you've actually received a certificate from the Copyright Office. You have to include that when you file an infringement lawsuit. If you don't have that, a court is not going to let your lawsuit proceed. So really important to have that copyright registration certificate. If you haven't registered yet, it's never too late. You can always go back and register a copyright, even if it's something you created 10, 20, 30 years ago. But the sooner after publishing the work that you go to the Copyright Office and register, the stronger your protections will be. The other thing is that if you end up in an infringement scenario and you've already registered the copyright and you already have the certificate in hand, then you can get right to drafting your complaint and submitting it to court. But a lot of artists haven't registered their copyright yet. Then they find someone's infringing their work, and before they can file that lawsuit, they have to register their copyright and usually have to pay the Copyright Office an expedited processing fee to make sure they get their registration certificate as soon as possible. And that's quite expensive. I want to say it's a couple $100 to do the expedited processing. And so it can save you a lot of time and certainly a lot of stress if you take care of your copyright registrations when the works are created and don't wait until you discover an infringement later on to do it. If you register the copyright within the first 3 months after publication, so very, very prompt registration, you can also become eligible for statutory damages and attorney's fees. So statutory damages are an alternative to proving your actual damages. So when someone infringes your work, maybe they released a bootleg copy of your film and they're making tons of money off of it, if you can produce evidence of the money they made from it, then go that route. If it's easy enough for you to assemble that evidence and prove to the court, the defendant here has generated millions of dollars from bootlegging my film, then, you obviously want to make those allegations and to prove those losses. But if it's a situation where the other party isn't necessarily making money off of it, but you still want them to stop, or you still think that you are, deserve some sort of remuneration for someone else's work, then you can elect to go with statutory damages, which are basically a sliding scale established in the copyright statute where the judge, after reviewing all the facts and legal arguments and making a ruling on whether or not an infringement occurred, if the judge finds that infringement did occur, the next step then is to look at damages. And with statutory damages, you can basically ask the judge to make their best assessment of what a fair amount of damages should be. And it's limited to a certain range between, I always forget the exact numbers, but somewhere between about $300,000 and $50,000 per infringement. And really the judge will make that determination based on the facts of your particular case. But the important takeaway there is that if you're eligible for statutory damages, you don't have to prove actual damages. You don't have to worry about trying to gather that evidence and trying to establish as a legal assertion that this defendant made exactly this money and here's my proof to show you that. You can just use the statutory damages and still get paid from that. Attorney's fees means reimbursement. So if you sue somebody and you win, you shouldn't have had to even incur those attorney's fees if it weren't for them infringing on your work. And so you're entitled to have the defendant pay you back for your legal costs in pursuing an infringement claim. But those benefits are only available if you register the work very, very soon after publication. There is another way you can get statutory damages and attorney's fees if you register your work within that first month of discovering an infringement. But that's 1 month is a really short time to do that. And, you might find that maybe you heard about something and didn't really do much. And then you heard about sort of a more egregious infringement a few weeks later. At that point, the clock already started running from the first time you discovered the infringement. So you really don't have a whole lot of time to go and do it, which is why I generally suggest to clients to go ahead and register your copyright as soon as you can. And then you don't have to worry about that stuff at all. So you've got all these benefits, and registration fees are really not that expensive. So I like to sort of think about it as a really, really cheap insurance policy against infringement. By registering promptly, you're going to give yourself statutory damages, attorney's fees. You're going to be all set up to sue for an infringement action if you need to. And then you'll also have that presumptive ownership and validity of your copyright. So you'll be in the strongest legal position you can be in if you register that copyright as soon as possible after the work is created for really a very, very small amount of upfront money. And these registration fees are paid just one time. There's no regular maintenance fees or additional payments you have to make. The other reason registration is important is because other methods of kind of documenting your work don't give you the same benefits the copyright registration has. So you may have heard of, the poor man's copyright of mailing something to yourself and keeping the envelope sealed. That doesn't give you statutory damages and attorney's fees. That is just proof that the work existed as of the date that that envelope is postmarked, but it's not the same as registering a copyright. A lot of script writers may be familiar with the Writers Guild of America has a script registration database. That is not the same as registering your copyright. So if you've already registered your script with WGA, you still will need to go and register your copyright in order to get these benefits that I've talked about here. Again, the WGA registry is really just a place to sort of indicate a date on which your work existed and it's sort of independently verifiable because you have this third party. But it's not the same thing as registering a copyright. So when you do navigate to the Copyright Office's website, there is some stuff you'll need to have in hand, ready to go, before you can actually press that final button at the end and submit your registration. There's a lot of information on this slide. One thing I'll highlight here for you is if you use contracts to transfer ownership, like if you have deal memos with your crew, and for whatever reason work for hire doesn't apply, you'll need to let the Copyright Office know that you obtained ownership by written agreement. If work for hire does apply, you'll need to let the Copyright Office know that work for hire was used to obtain copyright ownership from these other people. They don't ask to have you upload a copy of the contract or for proof of work for hire or anything like that, but they just want you to kind of, indicate to them what happened there. That way, if someone goes back and looks at the copyright registration records, they can see that they can see exactly what happened in terms of the structure of ownership of the copyright there. You'll obviously need the sort of basic information about the work, information about the authors and the owners. You should know that the authors' names will be public information and the owner's information will be public as well. So once you've registered a copyright and the Copyright Office has approved it, it will go up on the Copyright Office's public database, and anybody will be able to search for your work, for your name, and so on, and see that your name is there. If you've listed your address will be there, phone number, email, etc. Now, you can opt to only provide an email or only provide a phone. You don't have to give all three of these pieces of information. So if you're concerned about your address being out there, you certainly could just list an email address and not list anything else. You'll need to pay a registration fee when you are ready to submit your registration. And then you'll also need to upload a copy of the work to the Copyright Office. So the important point here is that you're gonna have to have the work more or less finished before you can go to the Copyright Office to register it. Now, like I said before, you can start a registration, save it as a draft, and come back to it. So if you have all this information, you know what information you need to put in about authors and owners and all of that, you can go and do all that. And then once the film is done, the last thing you have to do is just upload the work and then you're good to go. But whenever you do get to that point, you can't just submit a copyright registration application without the work being attached to it, because the Copyright Office needs to know what work is being claimed. They need to be able to see, okay, all this information on this form is attached to this particular creative work. And those will always be linked together. So when you upload a copy of your work to the Copyright Office, they take that copy and it goes in the Library of Congress along with all of the other copyrighted works there are. And then if anyone makes an inquiry as to a particular film or a particular script, they'll be able to verify, okay, yeah, this is the same film you're talking about. This is the same script you're talking about. And here's the copyright information about it. So I'm going to kind of sit on this slide for a while and just sort of talk through some of these things. And then I have one more slide that follows that kind of gets into this last point at a little bit more detail. But I just kind of wanted to talk. So, now that you have this understanding of how copyright functions within the film world and what you can do with it, and the fact that it's a piece of property that has value and can be commercialized, just want to sort of highlight some things where filmmakers now during this crisis can continue making money from their copyrighted works, even though things like live productions have shut down, And obviously a lot of, in-person interaction has limited certain things that you can do. One thing that I think is really interesting is that for filmmakers in particular, this crisis has sort of ironically created a ton of new opportunities. There's people in all different disciplines who have a need for technical assistance with audiovisual stuff. So, not only in sort of the more cut and dried things like education and corporate world and things like that, but there's tons of bands out there and musicians who are doing live streaming. There's venues that are trying to keep their doors open somehow and have used their stage spaces as an opportunity to do webcasts of a band playing on a stage. And so on that front, as filmmakers, there's people who definitely are looking for that sort of higher production value. They want to bring that high level quality to a live stream or even to a recorded content that can be used later, or made available on demand, things like that. On the creative side, for those who do narrative work or who write, I just looked this up last night. Every single streaming platform has seen an increase in streaming over the past couple of weeks. Every single one of them. HBO, Netflix, Amazon Prime, all of them. So while there is, of course, plenty of content already on those platforms, I can only assume that this means there's just in general an increase in demand for content. So to the extent that distributors and production companies and networks and streaming platforms are still doing business, which I think many of them are, and a lot obviously can be done via phone, email, uploading and transferring digital files and whatnot. There's still a huge opportunity there to continue creating original creative content. So to that point, obviously you can't go out and shoot anything new right now, at least not anything that would require, a large crew or having a full-blown cast. But, perhaps you have projects that you started working on a while ago and then you kind of got sidetracked in other things. Now's a great time to go back to those, finish those up, get the copyrights registered, and start sort of exploring your licensing and distribution opportunities. Along those same lines, there is some shooting and production that I think could still happen today. Not everybody's, a nature photographer necessarily, but that's an area where you can still go out and not run afoul of the social distancing rules. People seem to be very, very intrigued by seeing, shots of empty urban landscapes these days. And so at a minimum, even if this doesn't necessarily turn into content that you're going to try to commercialize right now, now could be a good time to sort of gather some good stuff and have it in the can that you can use for B-roll later, you can sell to other people. Because remember, footage itself is an audiovisual work, and that is eligible for copyright protection. So even if you take a piece of footage and you don't turn it into a scripted narrative project or don't use it in a larger documentary, you can still make money selling footage because as a filmmaker, you own the copyright in that footage as well. There may be some opportunities for those who have the skills to look into areas of filmmaking that maybe you hadn't really explored much before. So I have a lot of different ideas on that front. Maybe you want to look into animation. Maybe now's the time to try getting better at your drone skills, and get more comfortable with aerial photography in that way. As sort of a different tack, and kind of more specifically related to this moment in time that we're living through is there's going to be a lot of really interesting and compelling stories that come out of this time. We're going through a very, very dramatic period in history right now. And so those who, have already have a background in documentaries, or maybe those who are interested in getting into documentaries, might look around and see what kinds of interesting stories can be told. Again, even if you're not going to release that story right now or try to get something produced with a tight turnaround, this could still be a time while everything is going on to get those firsthand accounts, to start brainstorming ideas of what kinds of stories may be compelling, because this is something people are going to want to look back on later this year, this time next year, 10 years from now, 25 years from now. And so to be in this moment in history as people whose skills line up with capturing stories and retelling stories, now could be a really good time to explore that. Now is also a good time for a lot of good pre-production planning, right? I mean, tons of stuff already was happening in the film world via, long email threads with lots of people copied on them, producers navigating and working with line producers and lots of other people. So there's no reason that any of that stuff should stop right now, right? So, I know a lot of musicians, including a client of mine who's trying to get a music video made later this year. And, we know we're not going to be able to shoot anytime soon, but we can still get all of our people lined up, work on our treatment, make a shot list and get everything together we need so that when they do lift these stay-at-home orders, we're already ready to hit the streets and get the footage we need and get going. We don't have to, do all of our pre-production and wait till the shelter in place is lifted to do that. There's a lot that can still be done while we're stuck at home. Shifting gears a little bit, now's a good time to maybe explore more distribution options. Maybe not only do you have projects you've been, meaning to finish for a while, but maybe you even have, stuff that is already done and you want to get it out there in the world. There are tons of distributors out there. And frankly, I don't know too many specific names because there are so many of them, but they operate at a lot of different levels. There's the major streaming services. There's also kind of secondary streaming services that aren't quite as well known, but those platforms are fed by a wide range of different distributors. It's not like Netflix has one distributor who partners with them. Distributors come to them from all different areas with different types of content, and they're pitching things to Netflix to try to get stuff up on the platform, right? So there's lots of different avenues that you can navigate to get to those higher level streaming. But don't forget, there's also regional and local television. And in some markets, there's locally produced original content that gets broadcast within kind of a local area. I had some clients a couple months ago who were talking to a distributor who only served the Chicago metropolitan area. They're a distribution company, but the extent of their distribution only reaches kind of the greater Chicago area. So I have to imagine that there are other distributors like that who focus on other kind of regional markets. So there's a lot of opportunity there. It just takes doing some research. And one thing I would say kind of in connection with that is take some time while you're doing that research. Also take some time, set aside some time to think through kind of what you want your standard policies to be. Because you are, you may be an independent creator, but with respect to these parties that you're going to be entering into contracts with, you really are a business. And so it's a good time to really start thinking about your project as a business. And part of that means having some kind of standard policies that you follow every time you do deals with other people, right? So you might have a standard policy where our production company always retains ownership to our copyrights, and we only ever do licensing deals with distributors. Okay, you can go that route, but it's important to really think about how do you want to do that? What kinds of rates do you want to charge? Are you open to the possibility of doing exclusive licenses, or do you want to only do non-exclusives so that you can maximize how many outlets you can be on? and if we have the time, I'll talk a little bit more detail about that on the next slide. And then the last other thing to think about is there are these organizations out there called collective management organizations, which essentially serve as kind of a single point of payment for all of the productions and other things that are out there. They collect revenues, typically residuals from secondary markets, DVD sales and streaming and things like that. And then they pay those out to the members of those organizations. So in the film industry, that's generally pretty much occupied by the unions. So if you are a member of any of the various unions and you've been involved in union projects, it's possible that there are residuals being collected and you might need to just log into your account and see if that money's there. Or maybe you worked on a union project, but you haven't actually finished your union membership. You might be leaving money on the table. So it might be worth looking into your respective union, whether that be SAG-AFTRA if you're an actor, or WGA if you're a writer, DGA if you're a director. There's a lot of unions for below the line crew as well. And residuals are available through most of these unions because the unions use that collective bargaining to demand that, the contributors to a film, even if they're not going to be sharing in the copyright ownership, should still be getting some benefit when that film continues to make money. So that's sort of the power of the unions there. And it's worth looking to see if you have that available. So I know we're at 1 o'clock right now. I do have one more slide on just some sort of general tips for taking yourself from an individual freelancer to a small business. A lot of this stuff is pretty self-explanatory, so I'll just leave this slide up here for you to read. LLCs are a really important thing to have, especially for films where you're hiring crew and you have a lot of moving parts. There is, a huge risk of liability in a lot of different ways on a film production, whether it be commercial liability, contract issues, or it could be, workplace liability issues. There's obviously tons of electrical equipment on film sets, sometimes, dangerous stunts and other things. And so having that LLC creates a separate legal entity that will shield your personal assets from any judgments or other things. So, if someone sues your company and they want to collect on their judgment, they're only going to be able to collect from the LLC itself. They can't go after your house or your car, unless, of course, those things are owned by your LLC, but I don't advise people doing that. But the LLC, from a legal standpoint, actually creates what we kind of talk about as a separate person legally. It's legally distinct from you as an individual. And so that can have really important legal ramifications. Worth pointing out that Colorado is actually one of the cheapest states to register an LLC. It's only $50 for the registration fee. I'm also licensed in New York and Louisiana, and I know that both of those states are about $100 for LLCs. So really pretty low startup costs there. And if it's just one person involved in running the LLC, then there's really minimal paperwork as well. You really only need a contract for an LLC if there's multiple people who are going to be co-owners of the business. And then now is also a really good time to, make sure your web presence and your outreach to clients and customers is, as good as it can be, because, we have many, many fewer opportunities to do in-person networking, to make those kind of random serendipitous connections that you can experience from going to events and things like that. And so really the only way people are going to be able to find you and work with you is if they can find you online at this point. So, make sure that you have some kind of website, or at a minimum, some social media pages. And most importantly there is, if you have those, which I think that you should, make sure your contact info is everywhere. Don't make people hunt for your phone number or for your email address, because if they're trying to commission you for something, or they want to license your film and put it up on streaming platforms, but they can't get a hold of you, they're going to move on to the next person. And so, just kind of a practical point there, but it is important right now to really be as accessible as possible, because to the extent there are opportunities for you to keep making money, which I think there are. Obviously, the economy in general is in a bad shape right now, but for you as individual filmmakers, there's still a lot of opportunity, and you don't want to miss out on it by, not having your email address available, or by having some sort of typo and emails don't get through. So, take some time to work through that. So I have 2 slides here with some resources. The Copyright Office circulars are a really great little resource that the Copyright Office provides. They're PDF documents that are 1 to 5 pages in length. And they do that so that each individual document is not too overwhelming, but they have probably 70 or 80 different circulars on various topics. And I've highlighted for you a couple that are important for filmmakers here. There's an entire circular just on work for hire. Oddly though, if you go to this first link, copyright.gov/circs, most of the circulars are listed except for Circular 9. So I've given you the direct link for Circular 9 because for some reason there's no way to get to it from the Copyright Office. You can just do a Google search, Copyright Office Circular Work for Hire, and it'll come up there. There's also the Fair Use Index. So this is a really great tool. It's actually very new. The Copyright Office rolled this out maybe about a year ago. And it's a database with summaries of all of the federal cases in the United States that have addressed the question of fair use. And so if you have concern about fair use issues that involve particular types of copyrighted works, or issues that are related to the internet, the fair use database has a lot of different filters and search parameters you can use. And so you'll be able to kind of narrow it down to cases that are related to your issue, and read the summaries. You don't have to read the judge's opinion. They actually give you a nice little synopsis. And you can read through those, and you can kind of get a sense of, is a judge likely to rule in my favor here? And if all of the cases indicate that, judges are likely to rule in favor of someone who's in your position, then that's a good sign, and so it gives you at least a sense of where the courts are going with fair use issues, because every court handles fair use a little bit differently. And so the best way to understand fair use is to look at specific cases, and the Fair Use Index is a really, really great way to do that. They also keep it very up to date. So there are cases from, late 2019 and even early 2020 that are up there already. So anything that has been decided and a judge has issued an opinion on, it's in the Fair Use Index. There's also some good resources for contracts. These are just 2 examples. These are 2 websites that, in my opinion, are generally more reliable than most, but there are lots and lots of great resources out there. A lot of law firms have blog sections of their websites that address specific topics. So if you do have a particular legal question and you're looking to kind of research it on your own, Google searches where you get relatively specific will often bring up, law firm blog posts and other resources that you can rely on those as being accurate. But of course, you do have to be mindful of state-specific issues, because contract law is the province of each individual state. And so every single one of the 50 states has slightly different rules on how contracts work. Unlike copyright, which, like I said before, is federal and works the same way everywhere. But if you do look up contract information, make sure you're looking up information that's specific to your state when you do that. And then I have a second slide of resources here if you're interested in checking out SAG-AFTRA, Writers Guild. There's also an entertainment attorney named Mark Litwack who has a great website with tons of resources on his site. And I've used that when I have questions sometimes. He's got articles, suggested reading, all kinds of stuff up there. And again, that's just one attorney. There are a few other entertainment attorneys out there who have similar websites. And then of course, you know, if you do have specific questions or you'd prefer to talk to somebody in person, you know, reaching out to an entertainment attorney or someone who has expertise in copyright will generally be able to answer most of the questions that you'd have. So I know like we're a little bit over time here, but I'm definitely open to any questions if people have anything. You know, I'm happy to hang out here for a few minutes if people do have questions, or you can email me at this contact info we have listed here. Find me on social media if you want to just sort of keep up to date with the things that I'm posting and news that I'm announcing, things like that. And I also have my phone number listed. Please feel free to call me whenever, and we can coordinate consultation or even just a brief discussion, whatever you need. And of course, a huge thanks to CBCA. We've been working together the past 2 weeks and putting on these presentations every day for the past 3 days. So they've been amazingly helpful, and I really appreciate all their work in coordinating all of this. Looks like we have something pop up here. You're welcome. Thanks for listening. And like I said, any follow-up questions, anything we didn't address today, please feel free to reach out, and I'll be happy to give you my insight. I do have one other slide here that I just want to make sure is included in the recording, so I'm going to click there. This is something that filmmakers and photographers need to be aware of with releases. Not really going to spend too much time talking about this, but you know, this is an area that's completely separate from copyright law, so it's important that people who use a camera to create their work need to be aware of the privacy rights and publicity rights of the people whose faces are captured on screen.
I'll chime back in. Thank you so much, Max. I wish I miss doing live events when you can applaud people. So I'll just applaud you here, and I'll trust that everyone
unmute everybody, and we can go ahead and do
everyone can applaud. Thank you. That was so much great information. And we really appreciate it. We hope those who've been tuning in live, as well as those who are watching this recording in the future, learned a lot. So much great information, and we appreciate the ability to record these, as well as sharing the slides afterwards. Again, those will be available on CBCA's website on the Advancing Creatives page. Thank you to Max. Thank you to all for participating. Thank you to our sponsors who have been supporting CBCA and our ability to bring this kind of legal and business education to creatives in this time of great need, but also just into the future. This is information that our creative professionals and businesses always need to know and learn. So with that, I think we'll call it a day. We'll wrap up. Thank you again for participating, and have a wonderful day.